Welcome to this presentation on ethics provided by the Texas Board of Professional Geoscientists. This presentation will focus on the difference between ethics, morals, and business ethics, and includes some case studies and a summary of the TBPG Code of Professional Conduct. Ethics is a set of values that define or direct us to the right choice. If ethics are to be useful in practice, they need to affect the way human beings behave. Philosophers will argue that if a person realizes that it would be morally wrong to do something, then it would be irrational for that person to do it. However, humans often behave irrationally. Is this a personal moral code? Well, typically, yes. It starts with knowing the difference between right and wrong, which is often based on religious beliefs and societal customs. Sometimes morality is confused with religion, but the source of your moral code is not as important as the strength or soundness of it. It is important to know that personal moral codes are not a legal requirement. The difference between law and morality is important in a democracy. What should the relationship between law and morality be when we have separation of church and state? Should legislation reflect moral principles? Should judges interpret laws in light of moral values and principles? Should laws enforce morality? Are laws truly binding if they do not reflect moral principles? And lastly, is it moral to disobey quote-unquote immoral laws? When it comes to professional ethics, most people do not distinguish between morality and ethics. Remember that morality is your personal moral choice, while professional ethics involves analyzing all values and perspectives. As professionals, our moral code will not be sufficient. Rather, we must learn to include the perspectives of all involved, as well as applicable regulations. Let's take a look at the comparison between ethics and morals. Starting with the column on the left, what are they? Ethics, generally rules of conduct with respect to a particular class of human actions, a group, or culture, while morals are the principles of right and wrong. Do's and don'ts, you may hear it referred to as a moral compass. Where do they come from? Ethics are typically external. They're a social system, whereas morals are internal, individual beliefs. Why do we do it? Under ethics, it's because society says it's the right thing. For morals, it's because we believe something is right or wrong. The gray area. A person that strictly follows ethical principles might not have any morals. Likewise, a person might violate ethical principles to maintain moral integrity. Under morals, a moral person may choose to also follow ethical principles. The origin of the two words is different. Ethics evolved from the Greek word ethos, meaning character, while morals are derived from the Latin word mos, meaning custom. Acceptability. Ethics are governed by professional and legal guidelines, where morals are typically viewed as transcending cultural norms. Should religious or cultural beliefs influence your professional decisions? Let's look at a very high-profile case. Hobby Lobby made headlines for a few years around 2014 because of their policies for employee health care, specifically as it relates to women. Under the Affordable Care Act, for-profit corporations were required to cover contraceptives for female employees. In a landmark decision, the Supreme Court voted 5-4 that closely held for-profit corporations could be exempt from a regulation that its owners religiously objected to. This is the first time the High Court has recognized a for-profit corporation's claim of religious belief, but the decision is limited to closely held corporations. The Affordable Care Act does provide a government-sponsored alternative for female employees of closely held corporations that do not wish to provide birth control. This means that these female employees still have options, but they may not be as simple or as cost-effective. Hobby Lobby is owned by two families, the Green and Hahn families. These families contested only 4 of the FDA-approved contraceptives as shown below, those that prevent implantation of a fertilized egg. The families view this as abortion. It is important to note that all of these contraceptives have other uses and treat other conditions beyond preventing pregnancy. It's also important to note that all 4 are on the World Health Organization's list of essential medicines, those which are most effective and safe medicines needed in a health system. The Green family says it has no moral objection to contraceptives, only those that they believe constitute abortion. Because Hobby Lobby is owned by 2 families, they qualify as closely held. Because their corporate policy is not to open on Sundays, thereby allowing employees time for worship and family, there is ample evidence that religion plays a huge role in the corporation's management. The Supreme Court ruling indicates that religious freedom, i.e. morals, are now more important than legal healthcare mandates. The questions for you: were all sides considered in this decision? What about the women who use these drugs for treatment other than contraception? You should note that Hobby Lobby doesn't require all their employees to subscribe to the same religious beliefs as the owners. In fact, they don't require their employees to be religious at all. Should these religious beliefs of the family be forced on employees in this manner? So does this decision reflect ethics or morals? Let's look at another example from the U.S. Department of Health and Human Services. They have created a new Conscience and Religious Freedom Division. In January of 2018, Health and Human Services announced the creation of this new division housed in the Office for Civil Rights. Its purpose is to restore federal enforcement of laws that protect the rights of conscious and religious freedom in the medical profession. Establishment of this division reverses an Obama-era policy that barred healthcare workers from refusing to treat transgender individuals or people who have had or are seeking abortion. It appears primarily aimed at preventing healthcare workers from participating in abortion services that go against their religious beliefs. The Trump administration now says, understanding religious liberty to override anti-discrimination principles. This isn't the first time. In October of 2017, the HHS's Office of Civil Rights moved to allow employers to refuse to pay for birth control coverage. The director for the Office of Civil Rights, Severino, says, laws protecting religious freedom and conscious rights are just empty words on paper if they aren't enforced. No one should be forced to choose between helping sick people and living by one's deepest moral or religious convictions, and the new division will help guarantee that victims of unlawful discrimination find justice. For too long, governments big and small have treated conscious claims with hostility instead of protection. But change is coming, and it begins here and now. The strength of this new division is its protection of religious freedom under the Bill of Rights. The fear is that doctors and nurses could refuse service to anyone that doesn't conform to their specific religious beliefs. Now let's take a brief look at integrity. I'm sure we've all seen the phrase, integrity is doing the right thing even when no one is watching. We associate integrity with words like honesty, fairness, decency, good character, living in accordance with principles, or walking the talk. It may also mean being free of corruption and hypocrisy. people acting with virtue regardless of circumstance or consequence. Integrity is often thought of as the connection between ethics and morals. Let's look at an example that I personally see in my role as a university professor. I'm talking about academic misconduct. In a poll of 30,000 students, the Ad Council and Educational Testing Service found that almost 61% of students admitted to cheating. 16.5% of them didn't regret it and felt no guilt. 85% think cheating is essential. 95% of cheaters don't get caught. And the vast majority, somewhere between 75 and 98% of college cheaters, also cheated in high school. That same poll also found that only 41% of Americans and 34% of college officials consider academic cheating a serious issue. In another poll by Fordham University, they found that cheaters have a significantly higher GPA, 3.41 for cheaters versus 2.85 for non-cheaters. Many feel compelled to cheat because of significant academic rewards for high GPAs. Many universities offer financial incentives and awards for high GPAs. Student loans may be reduced or eliminated for high GPAs in certain degrees. Credit card companies offer higher cash back for high GPAs, and many degree programs have a minimum GPA requirement to even be admitted to that program. So why do students cheat? In a paper by Adil Khalid from 2015, students themselves reported that 71% cheat because they need to improve their grades. 38% cheat out of laziness or not wanting to study. 28% cheat because of stress, fear, or pressure. 26% cheat because of poor organization and time management. And 24% cheat because of lack of preparation. Do the ends justify the means? Have we created an education system where cheating is the norm? And if cheating is the norm, why won't it also be the norm in the workplace after graduation? Recent research indicates that corporate cheating scandals are on the rise as more employees are bending the rules at work to get ahead. In 2015, Volkswagen admitted to creating a device that allowed the company's vehicles to cheat emissions tests in the US. Engineers were asked to create an affordable, clean diesel engine with good fuel economy. It was a daunting, if not impossible, task, so they cheated. In 2016, Wells Fargo revealed that 5,300 employees had secretly opened millions of phony accounts in an attempt to hit sales targets and receive bonuses. Wells Fargo set unbelievably high performance goals. Managers were contacted multiple times a day to check progress toward opening the allotted number of new accounts. Many of those managers and their employees ultimately decided that they could not reach those goals using legitimate means. In a survey of more than 1,000 employees, a team from Arizona State asked, "What causes employees to cheat at work?" The answers were organizational pressure to perform at a high level. As pressure to raise performance levels increased, employees became focused on protecting their own interests rather than focusing on the organization's interests. Performance pressure angered employees and caused them to think about their own interests, resulting in lying about and overinflating their performance. In other words, they cheated. Corporate cheating scandals seem to be all over the news in recent years. Is cheating in the workplace becoming more common? The investigations of the scandals within Volkswagen and Wells Fargo revealed that these employees felt tremendous pressure to perform at high levels. Research suggests that many of those employees undoubtedly felt threatened and ultimately decided that cheating was the one way to meet the performance demands. Now let's take a look at business ethics. Your general ethics apply to business, but you also have laws and regulations that apply. Think about things like insider trading, bribery, discrimination, corporate social responsibility, and fiduciary responsibility. You may also have voluntary policies that apply. Many businesses institute such policies to gain public acceptance. Business ethics can be applied at the corporate level or at the individual employee level. Every employee must make ethical decisions in the completion of their job. Let's look at a couple of examples. The first is congressional lobbying. Lobbying is attempting to influence decisions made by a public official, usually to pass or defeat legislation. Lobbyists are professionals hired by a special interest group to represent their interests to Congress. I'll give you a moment to look over the diagram. In 2017, more than $33 billion was spent on congressional lobbying. Of that $33 billion, individual corporations report that they now spend about $2.6 billion for lobbying, $1.2 billion in the House and about $860 million in the Senate. The federal budget to run the entire House is $2 billion. Corporate lobbying expenditures began to regularly exceed the combined House-Senate budget in the early 2000s. The biggest companies have over 100 lobbyists representing them, and they spend $34 for every $1 spent by labor unions and public interest groups combined. 95 of the top 100 organizations that spend the most on lobbying represent business. Could ethics be compromised when corporate lobbying alone exceeds your entire annual budget and is almost 15 times your annual salary of $174,000? Did you know that about 1 in 4 former congressional members become lobbyists when they step down from their congressional seat, often earning 2 or 3 times that base salary of that congressional member? Next, let's look at perks and gifting. In a 2017 corporate gift spending survey, companies spent $23 billion in promotional products, averaging $79 per employee. About a quarter of the businesses spend more than that, at over $100 per employee. And they spend an average of $46 per employee to thank customers or prospects for their business. Most of these items are logoed: pens, mugs, t-shirts, etc. There are also non-cash incentives. Industries spend more than $90 billion per year on free trips, golf outings, and event tickets. Of that, $75 billion is spent on merchandise and gift cards, while $14 billion is spent on incentive travel. This type of spending has increased by 300% since the year 2000. We have numerous corporate gifting regulations. Think about the IRS, the Federal Acquisition Regulation, or the FAR, Judicial Conference Regs, Joint Ethics Regulations for DOD, Foreign Corrupt Practices Act for DOJ and SEC, and many states also have regulations on gifting. So how did gift spending increase by 300% in the last 17 years? Gifts include gratuities, favor, discount, entertainment, hospitality, loan, or any item of monetary value. It also includes services such as training, transportation, local travel, lodging, and meals. It doesn't matter if it's provided in kind, by direct purchase, or by payment with reimbursement. Federal regulations exempt certain items like modest food or refreshments, greeting cards, or items with little intrinsic value, plaques, certificates, and trophies. Rates and discounts, So think about a government negotiated rate for a hotel, rewards and prizes for contests, or anything paid for by the U.S. government under a U.S. government contract. Can $23 billion in gifts and $90 billion in non-cash incentives compromise personal ethics? Now let's look at a few case studies. Why do people abandon their business ethics? The first case involves permits submitted to the state of Texas for new coal-fired power plants between the years 2005 and 2009. Then Governor Perry asked TCEQ to expedite the permitting process for 17 new coal-fired power plants whose permits had been submitted. TCEQ granted conditional approval, but Texas Cities for Clean Air Coalition was formed to oppose the permits based on degradation to air quality in Central and North Texas, areas that were already non-attainment for air quality. A technical review of the permits by TCEQ indicated that air quality in North Texas would actually improve if these plants were built. A consultant hired by the Clean Air Coalition discovered that the air quality modeling in the permits had been completed using the opposite prevailing wind direction. Ultimately, only 3 coal-fired power plants were approved and constructed. Was the wind direction an honest mistake, or was it unethical professional practice? The second case is Enron, whose scandal in the late 90s revealed institutionalized, systematic, and creatively planned accounting fraud. In 1990, the COO, Jeffrey Skilling, hired Andrew Fastow as CFO, and he began establishing many limited liability special entities. Fastow then transferred liability into these special LLCs so that they would not appear in Enron's accounts. This resulted in the stock price continuing to increase, but many of the assets and profits were inflated or even wholly fraudulent. Lay, the CEO, sold $70 million in stock a few days before the losses were announced. His wife also sold $1.2 million, and he sold another $29 million in the open market. Their failure brought about the dissolution of Arthur Andersen accounting firm and the enactment of Sarbanes-Oxley in 2002. It contains new requirements for all U.S. publicly traded companies, management, and public accounting firms, and it also included new requirements for privately held corporations, prohibiting things such as willful destruction of evidence to impede a federal investigation. Over 4,000 people lost their jobs, and employees lost an estimated $850 million in Enron stock from their 401k retirement accounts. Lay was found guilty, but died before sentencing. Fastow was found guilty, but given a lighter sentence because he cooperated with the investigation. He was released in 2011. Skilling was convicted in 2006 to a 14-year term. He was released in August 2018 to a halfway house. The next case is Martha Stewart, who avoided a loss of $45,000 by selling her M-Clone stock the day before the stock value fell by 16%. Her broker at Merrill Lynch told her that M-Clone's CEO had sold his shares in advance of an adverse FDA ruling. Stewart was indicted on 9 counts and convicted in 2004 to 5 months in jail and a $30,000 fine. She ultimately rejoined the board of her company in 2012. Now let's bring it a little closer to home. These next few cases are typically geoscience related, and several reflect the violation trends seen at TBPG. In 2014, a treasurer for a professional geoscience society misappropriated or borrowed funds from the society and used them for personal expenditures. The professional society confronted their treasurer, who was a licensed PG, and reported him to the TBPG. The professional society's primary objective was to secure repayment of the funds and therefore did not file criminal charges against the treasurer. The professional society worked with TBPG and the treasurer to impose strict repayment conditions on the licensee rather than revoke his license and render him unable to repay his debt. The next one is Geoscience reports that are not signed or sealed. TBPG is seeing an increase in the number of reports submitted to TCEQ that require a PG seal but do not have them. TCEQ is now routinely referring these types of cases to TBPG. When a complaint case is opened against the PG, the typical response is, "I didn't know." Bottom line, PGs are required to know and follow the rules that apply to them, so these violations stand as written. Still under the category of Geoscience reports not signed or sealed, TBPG is also seeing an increase in the number of reports submitted to private clients that require a PG seal but do not have them. TBPG is receiving these documents from third parties. When a complaint case is opened against the PG, the typical response is, "I thought private clients didn't constitute public practice." Again, licensees are required to know and follow the rules that apply to them, so the violations stand as written. For geoscience done by a PE firm that is not signed or sealed. Typically, when reports without a seal are provided to either TCEQ or a private client, TBPG will open a complaint against the firm in addition to the licensee. This is also true when PE firms produce geoscience reports that are not signed and sealed. In some instances, no PE would sign or seal a report since they were not qualified to perform the geoscience work. In other instances, the PG that did the work resigned prior to the report being issued, and the firm issued the report without a seal. Lastly, others were under the impression that doing geoscience for a PE firm meant that no seal or signature of any kind was required. These violations all stand as written. PG license renewal without continuing education also becomes a problem. TBPG is seeing a number of continuing education violations, specifically for failure to obtain the required continuing education credits. When a PG renews their license online, they must check a box stating that they have completed their CE credits. When audited, if they cannot produce the proof of completing the CEs, they are typically cited with up to 4 violations and a fine of $400. As required, TBPG posts all violations to their webpage. The next one is an example of withholding information from a regulatory agency. What do you do when TCEQ requests all data from a specific compliance issue, but your boss directs you to respond to the agency with less information? He or she specifically directs you to exclude certain pieces of information from TCEQ that you know you have. What do you do? The next one revolves around intentionally selecting inappropriate sample locations. Let's say that you are reviewing a Phase 2 environmental site assessment that shows no impacts to soil or groundwater and recommends no further action. However, that site was a gas station for over 50 years. As you dig deeper into the Phase 2, you discover that the sample locations and depths presented in the report do not match the sample depths on the third-party lab report. The lab report indicates that all soil samples were collected at a depth of only 2 feet below ground surface, and therefore cannot possibly be representative of the site conditions. You reject the Phase 2, but do you report the breach of ethics to TCEQ and TBPG? The answer is yes. TBPG rules require you, as a licensed PG, to report known or suspected violations. There are many rationales for breaches of ethics. What I'm doing isn't really illegal, or nobody will ever find out what I've done, or the organization will protect me. The bottom line is that professional liability insurance doesn't protect you from doing things you know are wrong. For the last portion of this presentation, we will look at a few excerpts from the Professional Code of Conduct for the Texas Geoscience Practice Act. TBPG's purpose is to protect the health and safety of people and the environment. In addition to rules regarding licensure and professional practice, TBPG is required to provide a code of professional conduct. You'll find it in Texas Administrative Code Title 39, Chapter 851.101. It is binding on all license holders and gives TBPG the authority to impose sanctions. Additionally, it states that PGs and GITs, or geoscientists in training, are responsible for understanding and complying with the Act, the TBPG rules, and any other law or rule pertaining to the practice of professional geoscience. It is important to note that it does not define a standard of care. This slide simply provides a listing of the rules under the Code of Conduct for your reference. So I like to call this the highlights reel. It's simply the information from the Code of Conduct that's been summarized out of the rules. In the event of a conflict, the rules supersede the information in this presentation. Section 851.102, Competence Negligence. A PG or firm shall be qualified by education and/or experience in the specific technical areas involved. Note that the rule clearly states that the knowledge or skill is ordinarily applied by reasonably prudent PGs. To make this simple, signing or sealing work for which you are unqualified is incompetence. Section 851.102, Recklessness. A PG or firm shall not practice geoscience that is reasonably likely to result in endangerment of the safety, health, or welfare of the public. This includes disregard of substantial risk and failure to comply with regs. 851.104, Dishonest practice. A PG, GIT, or firm shall not defraud, deceive, or create a misleading impression. This includes advertising like LinkedIn or a company or a personal website. TBPG sees many violations where a license has expired and yet the advertising for professional geoscience work and the letters PG have not been removed. TBP generally sends a letter of advisement for these types of advertising violations if the individual works with us to quickly remove it. This same section notes that a PG may not directly solicit, offer, give, or receive anything of significant value, including services. 851.105, Conflicts of Interest. This section requires a PG, firm, or GIT to disclose any business association or financial interest that might appear to influence judgment. You must inform your client in writing and receive written consent to continue the work. This section also mandates that PGs, firms, or GITs cannot accept financial consideration from more than one party in connection with a single project without full written disclosure to both parties. This also includes suppliers, contractors, and consultants. Many times, the PG that did a phase one for a seller will be asked to continue on the project by the buyer. You can do that, but you must have full written disclosure and agreement by all parties for you to continue on that project. 851.106, Responsibility to the regulation of the geoscience profession and public protection. This section specifies that a PG cannot knowingly participate in a plan to violate the TBPG Act or rules, aid or abet unlicensed practice, or fail to prevent associates or employees from violating the Act or the rules. Further, a PG is held responsible for the use of their seal, signature, and other professional identification. You must report a loss of your seal immediately to the TBPG. That same section of the rules also requires reporting of known or suspected violations to TBPG. PGs are also required to keep records of the service that they have performed for no less than 5 years. And lastly, a PG is required to look at the environmental impact of their actions, including conservation of resources and energy. TBPG welcomes the submission of these types of complaints. We are a complaint-driven agency, meaning that we can't take action if we are not aware of the situation. Our complaint process relieves you of the burden of determining whether or not information constitutes a violation. All you need to do is submit the information that you think may be a problem, and TBPG will take it from there. 851-107, Prevention of Unauthorized Practice. PGs shall not practice in another jurisdiction. You cannot use the title Professional Geoscientist or PG unless your license is current, and GITs can't use their title or initials unless their renewals are current. Again, we welcome information concerning unlicensed practice. Your submittals of potential violations are key to maintaining the competency of the practice in the state of Texas. 851-108, Criminal Convictions. TBPG follows the Texas Occupations Code with regard to criminal convictions. TBPG can suspend or revoke a license or deny licensure for convictions. Licenses are automatically revoked upon felony incarceration. A person can apply for a new license if their previous license was revoked due to incarceration, but only after their release. 851-109, Substance Abuse. Again, TBPG follows the Texas Occupations Code regarding substance abuse. If substance abuse contributed to a violation of the TBPG Act or rules, TBPG can require a rehabilitation program for the licensee. Substance abuse may be deemed gross incompetency, and TBPG may order examination by a licensed healthcare provider for diagnosis and treatment. 851-110, Effective enforcement proceedings on application. TBPG cannot issue a license while there is a complaint pending, or if there is a complaint in another state, if TBPG has been notified of that complaint. 851-111, Professional geoscientists shall maintain confidentiality of clients. PGs can reveal confidential information only when they have fully informed consent of the client, or when it is required by law, or if the lack of disclosure would constitute a threat to health, safety, or welfare of the public. 851-112, Required reports to the TBPG. You are required to report changes in address, name, firm name, mailing address, etc. to the TBPG within 30 days of the change. Additionally, you are required to report a criminal conviction, not misdemeanors or traffic violations, or any other disciplinary or enforcement actions taken against you by a licensing or certification body related to the practice of geoscience. Lastly, 851-113, Duty to abide by board order and timely pay administrative penalty. Administrative penalties must be paid within 30 days. Failure to pay or abide by the terms of board orders is grounds for yet another disciplinary action. Application for license or renewal can be denied until penalties are paid. Any money submitted for a license or a renewal will first be applied to any outstanding penalty. The contact information for the Texas Board of Professional Geoscientists is found here, and specific contacts are listed on this slide. Thank you for reviewing this ethics presentation. We encourage you to comply with the TBPG rules by reporting substandard geoscience and practitioners to the TBPG. Complaints can always be submitted anonymously. I'll close by saying, do the right thing because someone is always watching.